Trustee Ramos? All right, so where are we on discovery in this case?
Done everything we need, Judge.
Okay, and was an offer tendered?
Yes, it was.
And sir, how old are you?
21.
All right, Ms. Ferguson, on this case, if I can have a 30-day reset for plea deadline date, and state, if you could do an acknowledgement for discovery, please.
Yes. September 29th.
All right, we'll be back on September 29th. At that time, you need to let the court know whether or not you've reached an agreement with the state. If you have not, your next setting is going to be a jury trial setting. Do you understand?
Yes, ma'am.
All right, in this court, docket is not at 9 a.m. Why were you late?
I was caught in traffic.
I'm sorry, what?
I was caught in traffic.
So
Downstairs and coming up and all that.
here's the thing. You gotta remember, school is in session. So there are gonna be a lot of people on the road, but everybody is required to be in this court at 9 a.m. Do you understand?
Yes.
So do not be late again, all right? All right, just have a seat and your attorney will bring the reset form to you. All right, thank you. All right, Richard Campos.
Morning, Judge.
Good morning. How's it going?
It's going all right. It's going all right. I'm excited about the football season too.
Oh, hey. All right, so Mr. Campos, you've been in this court to know. You can't be late. Do you understand?
I was later.
You won't be late again, Judge.
All right. So today's plea deadline date.
We have not reached an agreement. We'll request a jury trial setting, Judge.
All right.
Right from the start, the judge is laser focused. Discovery. That's the backbone of any case. If the defense isn't prepared, it can collapse everything. Viewers, do you think strict deadlines are fair, or do they trap defendants?
And is this criminal trial division or family violence?
CTD.
All right, Ms. Ferguson. Well, let me ask you, do you have the transcript from the co-defendant's trial?
No, Your Honor, we don't need one at this time.
All right. All right, let's go on the record. Court is calling 2024 CR 2339A, State versus Richard Campos. Can I have parties announced for the record for the state?
State.
Brian Oriel from Mr. Campos.
And are you Mr. Campos?
Yes, ma'am.
All right, so defense in this case, you say you have all the discovery?
Yes, Your Honor.
Right. And the co-defendant did have a trial, but you're saying you're not requesting transcripts and you do not need transcripts?
No, Your Honor, we were able to actually be able to view the testimony to see if we were going to need it or not. And at this time, we do not.
All right, so you understand, Mr. Campos, that this trial setting, if for some reason your attorney asks for the transcripts and they're not completed by the time the jury trial starts, then you're not going to have the transcripts. All right, Ms. Ferguson, need a jury trial date. How long do y'all expect this trial to last? I'm sorry, how long? 3 days, Ms. Ferguson.
I would agree with that, Judge.
I can do the September 8th.
All right, September 8th.
Okay, Judge.
All right, once you sign the reset form, you're excused.
Yes, ma'am.
Thank you. All right, Andrew Reyes. All right, so Norma, since the attorney who's the Spanish speaker has been placed on the case, has he already talked to him?
No, not yet, Judge, because we're waiting for Valentino to hit that document.
All right, so if you'll let him go ahead and talk to him, and then so that at least he can have conversations with him while I do this. All right, on this case.
That's what I put on the list. That's not what I got here.
All right, do you have all the discovery? I know there was an issue with cases being moved.
No, Your Honor, that I know. I've got the paperwork on my client. They uploaded paperwork on the co-defendant, but I have not seen any videos or anything of that nature that I would assume they're going to be since there was searches of the houses.
All right, what videos?
Yes, sir. See, with the body worn camera that I asked to be submitted, and the videos still haven't quite transferred over through their pool, but I will see that that is done.
All right, Ms. Ferguson, I need a 30-day reset for discovery.
September 29th.
All right, this will be the final discovery. So September 29th, we'll come back and make sure that your attorney has everything. Thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you are excused.
Are they short?
Tony Hernandez.
Thank you.
All right, Ms. Ferguson.
Yes, ma'am.
On Miguel Aguilar on page 8, can you give me a 2-week reset, please? That's the one who you said was being taken to the.
Oof. Getting called out in open court for being late? Brutal. But here's the thing. Judges demand discipline because if they don't, chaos rules the court.
Hospital. And then on Oscar Orozco Naranjo. All right, if you guys can come forward, please. All right, the court is going to call 2025 CR 008245 State versus Oscar Orozco Naranjo. Could I have defense announce?
Valentina Kogut on behalf of Oscar Orozco Naranjo.
All right. And we have an interpreter. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right. You can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right. Mr. Naranjo, your attorney has filed a motion to withdraw. She believes that you would, it will be easier to communicate if you had someone who spoke Spanish. Is that correct, counsel?
Yes, sir.
All right. Do you have any objection to this attorney withdrawing and an attorney be appointed to you who is bilingual?
No.
All right. Then your motion to withdraw will be granted. Thank you so much. All right. And then counsel, if you can state your name for the record, please.
Abelardo Garza.
All right. And do you speak Spanish fluently?
Yes, Your Honor.
Right. And are you able to represent Mr. Oscar Orozco Naranjo?
Yes, Your Honor.
And Mr. Oscar Naranjo, do you have any objections to this attorney being appointed to represent you?
Yes. Yes.
All right. This is what I mean. And I'm just going to repeat it because maybe my question wasn't as great as it should be. The previous attorney who was appointed to you did not speak Spanish. This attorney speaks Spanish. So this attorney will be appointed to represent you. Do you understand?
Yes.
All right. Then you'll be representing him. And counsel, do you want a reset?
Yes, Your Honor. I'd like time to look at it. I discussed it with him, and I need to look at the discovery and see what's going on.
All right, Ms. Ferguson, if I can have a 30-day reset on this, please. All right, you will be brought back on September 29th. And according to the record, your client does have a hold. All right, Alcaldiel Ramirez. And counsel, in this case, are there any applications?
Yes, Your Honor.
Okay. All right, so is there an application for community supervision on this case or just deferred?
It's an application for probation, Your Honor. I think they're opposing deferred.
All right, so are they opposed?
Not applying for deferred, yeah.
All right, so on this case, are you all opposed to community supervision?
Yes, sir.
All right, so any objection to the court? Okay, I see how you did it. All right, the court is calling 2025 CR 008662 State versus Alcaldiel Ramirez. Can I have parties announced?
Lauren Espinosa for the state.
Abelardo Garza for the defendant.
All right, and the interpreter has previously been sworn in, but for the record, would you state your name?
Arlene Abrams, license number.
This is the courtroom equivalent of going all in. No plea deal? Then it's trial time. High risk, high reward. What would you do? Take the deal or roll the dice?
2081.
All right, Mr. Ramirez, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
And counsel, do you speak Spanish fluently?
Yes, Your Honor.
And have you been able to communicate with your client in Spanish?
I have, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ramirez, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Ramirez, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
All right, you're charged with driving while intoxicated third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses, state? The state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Right.
And did you intend to give up those rights and enter into a plea in this case?
That's right, yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Right.
Did you understand if you're not a U.S. citizen, by entering a plea in this case, you could be deported, not allowed re-entry into the United States?
Pause here. This is huge. A defendant has the right to fully understand their trial. Without proper language access, justice fails. Imagine fighting for your freedom in a language you don't speak.
And denied naturalization. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,000 fine. The state is opposed to your application for community supervision. Did you understand that to be the plea?
Okay.
No, did you understand that to be your plea bargain agreement?
Yes.
Defense, is that the plea?
That is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor, I have not.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. Seek out for State's Exhibit 1 and all attachments.
No objections, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
All right, and state, you may be excused. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and the review the same. After reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence.
This is where the system gets tough. Repeat DWIs aren't seen as mistakes anymore. They're seen as a pattern. But here's the debate. Should repeat offenders get treatment? Or is prison the only...
To find you guilty, and the court will find you guilty. Ms. Ferguson, I need a date for PSI.
Yes. I can do
And I'm
that.
so sorry. How did he plead?
No contest.
Thank you. Yes.
October 13th.
All right, we're going to come back for October 13th for sentencing. I'll request a PSI and TAP evaluation. I'll base my decision on your application based upon any evidence that's presented to the court. John Barry. All right, so what are we here for? Is this for a motion?
This is a motion to revoke probation, Your Honor. My client does intend to plead true.
All right, could I have the motion to revoke probation on this case, please? It's John Barry on page 9.
What are we doing? I'm
Yes.
so sorry, Judge. I was not ready.
No problem.
I don't even know if they did a search, Judge.
Okay. Renee, did you do a certification on this?
Oh, Your Honor, you know what? My apologies.
All right.
We get to do that.
That's what it was, Judge. We didn't have it ready because we didn't have the search.
Okay.
I do apologize, Your Honor.
Oh, hey, it happens. It's a Monday.
Manic Mondays, so they say.
I just talked about the back real quick, Judge. If that's everything okay.
All right, thank you.
Your Honor, can you give me that clause number for John Barry?
Yes, that's 2025 CR 012-861.
Thank you so much.
Yeah.
All right, court is calling 2024 CR 012861, State versus John Barry. Can I have parties announced?
Lauren Espinosa for the state.
Renee Munoz on behalf of Mr. John Barry.
And are you Mr. Barry?
Yes, ma'am.
All right, did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same John Cowan Barry Jr. who was placed on community supervision in 2024 CR 012861 for the offense of evading arrest detention with a previous conviction on February 27, 2025 for a term of 4 years?
Yes.
All right, state.
Yes, Your Honor, state is proceeding on violated condition number 41, which states on or about the 29th day of July, 2025, in Bexar County, Texas, the defendant, John Cohen Barry Jr., did then and there fail to comply with the rules and regulations of the felony drug court in violation of condition 41.
How do you plead to that, true or not true? And state, are you waiving the other allegations?
No objection from the defense.
All right, did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, ma'am.
Court will find violation of condition number 41 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke sentence to 2 years, as well as take into consideration clause number 2025 PF 29310.
Your Honor, we would just ask if we can just be heard in terms of the time of confinement with certain justifications related to substance use disorder.
All right, and the case that you're asking to be taken in consideration, what were the last 4 digits again?
29310.
And what is that offense?
That is possession of controlled substance, 51.
All right. So are you in agreement with revocation?
Yes, Your Honor.
Okay. And then the court then will hear your argument with regards to sentencing.
Thank you, Your Honor. In terms of the punishment to be assessed by the court, we asked the court to take judicial notice on the court summary provided by probation that he did successfully complete lifetime recovery inpatient for the dates of March 14th, 2025 through June 30th, 2025, which he was issued a certificate of completion for that inpatient lifetime recovery. We are aware that the court knows that he was subject to felony drug court conditions. He did suffer a relapse in which he self-admitted to felony drug court that he was using substances. So there's no dishonesty behind his issues, Judge. He did kind of fall off. He was at a sober living home, and then he did abscond from there upon release.
Probation is mercy. Break it, and mercy ends. The question is, should one relapse erase second chances forever, or do people battling addiction deserve another shot?
Relapsing. He did state reasons for doing so, where he was trying to get back to his family members that live in New Mexico. He did state that his grandmother is suffering from cancer, lung cancer. It's very serious, as well as mother that has diabetes. So there needs some help. We do believe that since Mr. Barry is not from here, San Antonio, he didn't have the proper support system. So that's why I think he's proceeding with this route, trying to resolve these issues, to get back to his family, to provide the support that they're needing, Judge. He hasn't been to state jail before, and this is my understanding is an evading arrest seconds underlying offense. So we asked the court to weigh all those factors and announce the punishment. We were asking for less than the 2, Judge. We'd be asking for 10 months in a state jail facility based upon his issues with substance use. The fact that he picked up a new case is this possession case, nothing violent, and doesn't have a violent history, Your Honor. For those aforementioned reasons, we're requesting less than the 2 years.
All right. So the court is aware that this is a evading with on foot. It's not in a vehicle. But also the court is noting that you absconded. That's a problem. And with felony drug court, I know that if you tell them what your issues are, they would have made arrangements with regards to any health issues your relatives may be having. Court is going to grant the motion, sentence you to 18 months in the state jail facility, give you credit for any time served, taking consideration 2025 PF 29310, and the court will give you a credit for any successful inpatient treatment. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that means, you'll need to speak to an attorney. Do you understand? And I'll also request the therapeutic community. I have no authority to force them to place you in the program. I can't order that, but they'll see that it's in the judgment that you need help with any type of drug addictions. It does not increase the length of time that you're in custody. It's just to help you with your addictions.
Your Honor, would the court consider presumptively granting him diligent participation credit upon him doing substance use classes, vocational and educational training in the state jail facility?
I will consider that once I receive it.
Yes, sir.
Right. All right. So here's the thing. When you're released from custody, if you truly want help with your drug or alcohol problem, if I'm still here when you get out, I'll help you find a sober living house. But at the end of the day, if you continue the path on that, you're on, only one of two things going to happen. Either you're going to end up in somebody's prison or jail for the rest of your life, or either somebody's going to be identifying your body, because the last time you use may be the last time you use. You understand?